Apologies for keeping you waiting. We're going to have to give you a little bit extra time.
Very grateful. Well, we were in the authorities bundle at 1, and we just looked at the Government of the Republic of Spain and National Bank of Scotland. Your Lordships will recall that the Lord Justice Clerk, you don't need to look it up, at page 160, described the effect of the decree as being the effect of that decree was to subject all owners of vessels registered in Bilbao to the absolute control and direction of the Spanish government authorities in the matter of marine transport services. So it was a complete switch of service over to the authorities. That brings us to the Christina, which is tab 7. It is difficult to apply the forensic laser to distill from this a common theme, because when one reads the judgment, you end up with, I think, slightly different views, and certainly different views as to whether or not the absolute authority, absolute immunity principle applies. But could I just take your Lordships through the various ways in which it was explained? At the end of the day, none of what was explained in this case supports my learned friend's case. That's the principle. It doesn't matter what view you take. The one thing it does not do is support the level of control that my learned friend is arguing for. One starts at page 125 of the bundle in the judgment of Lord Atkin. I won't repeat, it's too well known to...
Which bundle this is in?
So it's bundle, authorities bundle 1 at tab 7, page 125. 125 is the very famous passage from the second paragraph down. I won't repeat it, it's extremely well known, which establishes the two principles. Page 126, his lordship said, at the top of the page, it seems to me clear that in a simple case of a writ in rem issued by our Admiralty Court in a claim for collision damage against the owners of a public ship of a sovereign state in which the ship is arrested, both principles are broken, the sovereign is impleaded and his property is seized. In my opinion, the facts of this case establish the same breach of the two principles in the illustration just given. If one looks down just a few paragraphs down, it says that the Spanish consul enters the ship, and then he says, and that from and after the July the 14th, the masters, officers and crew held the ship, not for the owners, but for the government. And that by the master, officers and crew, the government were in fact in possession of the ship. I cannot pay serious attention to the suggestion that all the consul intended to do was to supply a well-affected new master on behalf of his owners, having broken into the vessel and removed the non-Republican officers. Over the page, at 127, towards the end of the long paragraph, he identifies that in the present case, where persons claiming an interest are the only persons entitled defendants, and the Spanish government are the only persons claiming an interest adverse to the plaintiffs, I have no doubt not only that the government were in fact impleaded, but were intended by the plaintiffs to be impleaded. Then he says, missing a paragraph, but for the present case is not one of control for public purposes, but of actual possession for public purposes. At the top of the next page, he then says, in the present case, I find it unnecessary to decide many of the interesting points raised in the argument for the appellants as to whether the ship was rightly in the possession of the government, what was the extraterritorial effect of the Spanish decree, what implied restrictions in different circumstances might be attached to sovereign immunity when, if ever, the assertion of the sovereign as to his property or possession is conclusive. And then he says he just thinks one shouldn't be offering an opinion on that. That was not the same as some of the other lordships. The Lord Tankerton, at the bottom of page 128, last paragraph, agrees with my noble and friend on the woolsack, and then says, further, the order sought in the present case would necessarily displace the de facto possession of the Spanish government, and I agree with my noble and learned friend that the doctrine of immunity of the property of a foreign state dedicated to public uses includes the case of actual possession for public use. He then doesn't express much more. Lord Macmillan, page 131, first paragraph, my Lord's various topics of the first importance were mooted in the course of the argument on this appeal, which it's unnecessary and inexpedient to discuss, but it may not be out of place to indicate the general principles which provide the setting for the particular problem which your Lordships have to solve. And he then goes through some of the principles, concluding on page 133. With these observations, I am content to express my agreement with what I understand to be the opinion of all your Lordships, that this action, which is directed to take, ultimately if necessary by force, a Spanish ship requisitioned for public purposes by the duly recognised government of Spain, and lying in a British port out of the possession of that government, cannot be allowed to proceed. That appears to me to be, according with my Lord Sumption's analysis, that he was accepting at least that the requisition had a validity there, whereas Lord Atkin was saying, well, it's just about possession. It's the fact of possession. Lord Wright gives a rather more extensive judgment, and page 134, about a third of the way down, he sets out the facts, which start on July the 9th, 1937. He attended the office, and it goes through the relevant facts, making it clear that the new master and mate at the bottom of the page have sworn that at all material times they and the crew have had continuous possession of the ship on behalf of the Spanish government and have held themselves and the ship at the government's disposal, subject to the arrest by the court, which was effected by the warrant. The expenses dispersed by the Spanish government, and then over the page he then refers to the Spanish consul at Cardiff acting with the authority of the relevant diplomatic office in the UK, refers to the decree, and then about halfway through that paragraph says, the decree recited inter alia that in order the better to be able to meet the requirements of the war, the government considered it desirable to exercise immediate and direct control over services of marine transport in order to carry into effect the plans of supplies, evacuation, etc. So again, it is removing the owners and taking immediate control and possession in this case. He then goes on page 136, that the application in this case, to set aside the writ by the government, was, it says, claimed and is entitled to possession of the said ship under the said requisition. So the assertion was that it was lawfully entitled to the ship or to possession of the ship under the requisition.
Where do we see that?
Top of page 136, it says, among the affidavits in support of the application was one from the councillor of the Spanish embassy in London, affirming on oath that by virtue of the decree of the government of Spain claims and is entitled to possession of the ship under the said requisition. And then at the bottom of the same page, the last paragraph, the respondent government does not contend that it is the owner of the Christina, but says it is and was at all material times in de facto possession of the Christina, and was therefore, without its consent, impleaded by the writ in rem, claiming possession adversely to its actual possession. He says that's inconsistent with its position as an independent sovereign state. It further contends that the action involves a claim to interfere with its right of direction and control, coupled with actual possession acquired by reason of the requisition. So that it was putting in place the legality of the possession. This, though not ownership, it is said, a right in the ship in the nature of property, and was, as being the property of an independent sovereign state, immune from the interference of the court, either by the arrest or by order annulling the requisition and giving possession to the appellants and ousting the respondents from possession. Then he deals again with the general understanding of the word requisition. The word requisition, while not a term of art, is familiar and has been constantly used to describe the compulsory taking by government, invariably or at least generally, for public purposes of the user, director and control of the ship, with or without possession. In my judgment, both contentions are well founded, and the order of the courts may be sustained on either ground. Again, requisition as a concept is that complete ouster of the ownership rights of the owner and direct control, direction and possession effective, either because they have taken possession or because the master of the vessel is now taking orders from them. The Page 138, the first paragraph starting on that page, just identifies that the first of the two rules is relevant, namely the sovereign cannot be directly or indirectly impeded. And then 140, which echoed in my Lord Sumption's judgment in Belhaj, about 5 or 6 lines down, a judgment in rem is a judgment against all the world, and if given in favour of the plaintiffs would conclusively oust the defendants from possession, which on the facts I have stated they beyond question de facto enjoy. The writ by its express terms commands the defendants to appear or let the judgment go by default. They are given the clear alternative of either submitting to the jurisdiction or losing possession. In the words of Lord Justice Brett, the independent sovereign is thus called upon to sacrifice either its property or its independence, and that's the claim to the entitlement to possession based on the requisition. At the bottom of the page, he identifies the fact that the modern and statutory form of the writ in rem turns into a liability in personam, thus the writ in rem becomes, in effect, also a writ in personam. This emphasises the view that the writ directly impledes the Spanish government. The crucial fact in this connection is simply that de facto possession was enjoyed by the Spanish government. The position would obviously have been quite different if the respondent was seeking to obtain possession by the process of the court instead of resisting an attempt by the process of the court to oust it from actual possession. So that seems to mirror what they were saying in the National Bank of Scotland case. In the present case, the fact of possession was proved. So in other words, the prima facie entitlement to possession was simply because they had it. It is unnecessary here to consider whether the court would act conclusively on a bare assertion by the government that the vessel is in its possession. I should hesitate, as at present advised, so to hold. But the respondent here has established the necessary facts by evidence. In other words, there's an assertion of a right based on the requisition and the fact of actual possession. It's unnecessary to consider by what mode the respondent obtained possession. That, I think, was a reference to arguments that it was unlawfully obtained in the civil law in the United Kingdom because it was an act of trespass, effectively, and they broke in. It's enough to ascertain that it had possession at the time when the claim to immunity was made. He then goes on.
Is it relevant to bear in mind that actually title is rather an elusive thing in the common law, and that ultimately what one is often deciding is who has the better right to possession? So that if you're in possession, on the face of it, you've got a right to maintain that possession. If somebody comes along and says, no, you should go out, that is an assertion of a better possessory right. And so, essentially, there is then a proprietary conflict.
And in this context, they also established a legal foundation, a prima facie legal foundation, because the government's assertion was they had the right pursuant to a decree.
I mean, a right of exclusive possession is normally a form of proprietary interest. Yeah. It may be chronologically limited, but while it subsists, it is an interest directly in the property as opposed to a claim against the person who has some other right.
I agree.
But is there then, can you then maintain the distinction from execution? I suppose in execution the answer is that you're not actually concerned with
Comes back to section 13.2a. If the property was in the possession of the state, I couldn't get an injunction or an order for delivery up. End of story.
It's not execution, is it? I mean, this is
not execution. No, quite.
And the same principles would not necessarily apply to execution.
That's what I was asking.
Although it wasn't probably necessary to say something about that.
My Lord, yes.
Yeah.
I'm sorry, and just to continue so he says the first ground is enough on page 141. Then page 142 is the argument that they didn't have property. So the appellants, while not contesting the general principle, have denied that it applies to the facts of the present case for various reasons. In the first place, they have relied on the fact that the Spanish government had no property in the sense of ownership in the Christina. And they refer to the Parlement Belge, but the rule is not limited to ownership. It applies to cases where what the government has is a lesser interest, which may not be not merely proprietary, but not even possessory. Thus, it's been applied to vessels requisitioned by a government where in consequence of the requisition, so that's the legal right, the vessel, whether or not it is in the possession of the foreign state, is subject to its direction and employed under its orders. So that's dealing, as I said right at the outset, with the case where a vessel, for example, is on the high seas, the communication comes in, a requisition has been given, and the master, whether on instructions from the owners or of his own volition, says, right, well, I'll now take my orders from the state. There hasn't been an act where a state officer has gone on board, but the vessel has now been subjected to the complete direction and control of the state, and it, in effect, has possession by that means. That's a million miles away from where we are in the present case. That was a separate ground in the Porto Alexander and the Broad Main, and he says the Broad Main was a vessel requisitioned by the British government under what was, in fact, a compulsory charter party and hiring. Another way of looking at it, how it creates a legal right. The government, it was held, could not be deprived by the order of the court of her services, nor could the court interfere with her so long as she was in the Crown's employment, though any rights against the owners not affecting the user by the Crown were preserved.
Well, that's an example of a purely contractual right, isn't it?
My lord, yes.
Because the Broad Main was about a standard time charter. It wasn't a bareboat charter or anything like that.
And then so he says the last point does not arise in actions for possession as contrasted with actions claiming a lien. And that was, it goes back to the discussion we had at the beginning, which my Lord Sumption, Lord Mance, said in Belhage, one needs to look at the nature of the proceedings to ascertain whether a legal interest of the state is being affected. Over the page, 143, the end of the paragraph, the first paragraph, in my judgment, on the facts of the present case, the requisitioning of the Christina under the decree gave the Spanish government a right or interest in the Christina, whether called property or not. So he appears to be holding, as my Lord Sumption said, that the fact of the requisition gave them the legal right, a possessory right, although he didn't really mind whether he called it a property right or not, but it was enough to establish the claim to immunity.
Was any of the three cases referred to in the bottom half of page 507?
My Lord, sorry, I didn't hear that.
Was any of the three cases referred to in the bottom half of 507 an execution case?
I don't believe they were. I think they were all
actions in rem.
I don't know about the Jupiter.
Right. Okay.
In 143 of the bundle.
It looks like a straightforward claim.
Yes.
For the right to possession.
Yes.
Looks like it anyway.
Yeah. And that's my understanding certainly is almost all of the requisition cases are claims for possession by the original owner against the state who's got it.
Looks like a case which resulted from the Russian Revolution, from a takeover of the vessel.
Yeah. Then, again, still with Lord Wright, halfway down page 143 in the bundle, having referred to the Jupiter, he says, it was said in that, apologies, it was said that such seizure constituted a wrongful act which was a breach of international comity and excluded a right to claim the reciprocal comity of immunity. So that's where it says wrongdoing deprives you of immunity. And if one goes on to the next page, again, just under halfway down, there's a sentence that starts, it must also be noted in the present case that the Christina, even when in Cardiff docks, may, as being a foreign merchant ship, have a different status from an ordinary chattel on land. But as the relevant fact here is that the Spanish government had in fact requisitioned her, that means going back to when she was on the high seas outside the dock, there is no need to consider whether in any sense or to any extent she was subject while in English territorial waters to the law of her flag or to the operation of the Spanish decree. So, as I understand that, what he is saying is, if it had been like this case in Scotland where they'd been berthed in Cardiff at the time of the decree, then it would have been a different position. But here they were on the way from the Baltic, as the Lloyd's reports show, at the time of the requisition, so it took effect because it was a Spanish flagship. And then goes forward to Lord Morn.
He expressly distinguishes in the last sentence of that paragraph the case where there was a requisition within the territorial jurisdiction of the requisitioning state.
Yes. But the next sentence, nor is it necessary, even if it be competent, for the court to debate whether the decree was validly made under Spanish law. And that's what I was inelegantly trying to explain before. I think that, at least in some of the judgments, there was an assertion of the legal right based on the decree. The fact of the decree and the possession was enough. You couldn't then go in to determine whether or not that was a valid claim. So they proceed on the basis it is a valid claim. It would have been different had the Spanish government, as in the Scottish case, been the plaintiff, in which case they would have had to have proved title.
Yeah, I mean, and that's consistent with section 6.4a,
Exactly.
where possession or control is a stopper by itself, whereas an interest has to be proved by prima facie evidence.
Exactly, Mark.
Yeah.
That's exactly right. And that example also, in my estimation, is very dangerous to look at different sections of the Act. My learned friend just focuses in on section 13b on execution. You also have to look at section 13.2a, and they provide the complete range of protection. Page 149, sorry to keep this.
149?
149 of the bundle,
Yeah.
514. In the middle of the page, they actually set out helpfully what the basis of the Spanish government's case was. The respondents entered a conditional appearance on the 27th of July and moved to set aside the writ and arrest for the following reasons: that the steamship Christina was, at the time of the writ in this action, was issued the property of the government of Spain, a recognised foreign independent state, and that the said state declines to sanction the institution of these proceedings in this court. That was dropped in the proceedings. Then this one was maintained, that at the time of the issue of the writ in this action, the steamship Christina was in the possession of the Spanish government by its duly authorised agent. At the time of the issue of the writ in this action, the Spanish Republican government had a right to the possession of the steamship Christina, that this action impledes a foreign sovereign state, namely the government of Spain. That was the one that was maintained in the action, and that was the right founded on the decree. Over the page, I won't read it, but page 151 to 152, from the paragraph starting the immunity of a foreign government, effectively sets out exactly the same analysis as was in the Scottish case, because he goes through saying the immunity of foreign government as regards property does not stand on the same footing. He explains the difference of the different causes of action and whether you're a plaintiff or a defendant. And so, for example, concludes at the end of that paragraph on 152 that there is no authority for the view that if he, being the ambassador, wrongfully obtained possession of valuable jewellery in this country and it was in the hands of a third person, he could claim to stay the proceedings by the rightful owner against that person to recover possession of the jewellery merely by stating that he claimed it. He would have to prove title, and that's really what the Scottish case said as well. His conclusion was at the end of 152, if the foreign government wishes to recover property in this country, I am of the opinion it must, subject to certain exceptions, prove its case. If it is rightly or wrongly in possession of property in this country, no action can be brought against it by persons claiming title to or any interest in such property. So that seems to be based simply on, once it's in their possession, you can't go any further and you don't claim against them. So as I say, it's difficult to ascertain a single basis, but it is either that they were accepting that the decree passed title because it was on the high seas, as my Lord Sumption has said, or that the assertion that the decree had that effect coupled with possession was enough to stop the inquiry, or it was just the fact it was in possession of the state. Whatever else, when they're talking about possession and control, they are talking about a situation where the whole vessel is actually employed in the service of the state under its complete control to the exclusion of the owner's rights and interests. That is not this case by any stretch of the imagination. My Lords, bearing in mind the time, I won't deal with the Dolphus Mead and Rahim Tula case. I anticipate from the questions to my learned friend that the Lordships have got the points I would make. We've set them out in our written case in any event. The same is true of the Australian Federation of Islamic Councils, which was a tripartite contract case. It doesn't apply in the present case. And it brings me finally to my part 7, which are some miscellaneous points, which I'm not sure how far they go, but they arise out of some of the submissions my learned friend made right at the end of yesterday about BIL. Could I just start by asking your lordships to look at volume 12, tab 112, page 3255. And I don't criticise my learned friend for this because he's only been involved at this stage. Some of us were involved right at the very beginning in the original arbitrations, and it's not entirely easy to follow this through. But this is the host government agreement, which my learned friend was referring to and making assertions that Bill had some kind of compulsory purchase rights. They don't.
Can you give me an electronic page number for that?
3255. Should be Article 4.
Okay.
And your lordship will see Article 4.1. The way it worked was that this was an investment by a consortium headed by BP. The MEP participants are effectively, with one exception, which is an Azerbaijani state entity, private entities. Under 4.1, Roman 2 to 4, as you would expect, they were given rights over land. And in Roman 4.14, each of the MEP participants is given the exclusive and unrestricted right and privilege to construct, own, use and possess and control the facilities. So the pipeline that my learned friend relies on is actually owned by a private consortium, and the land is owned by a private consortium. So it's not got anything to do with state interest. And if one goes forward in that bundle to page 3315, as one would expect with a project of this magnitude, there were various phases of the project. So Appendix 4, Section 1, deals with the right to land, the corridor that is identified for the land, which is identified as the preferred route corridor in 2.2. And one can see in Section 3 on page 3317 that the MEP participants effectively determine that corridor, and they then have rights of entry into all of the land. So the compulsory purchase phase was undertaken as one would expect when they were actually in the planning and design phase. And one can see that if one takes up volume 13 of the record and goes into behind tab 114 at page 3621.
Sorry, 6-3.
No, 3621, my lord, my apologies. This is in the turnkey, this is in the construction contract between Botaş and Tepe. And it's just a shorthand, but if one looks at the definition of detailed engineering phase, the second phase of the project being performed by the employer, encompassing the detailed engineering services for the pipeline, pump stations and Ceyhan terminal. And it is under 3, coordination of the securing of provisional rights to the permanent land for the benefit of the MEP participants by entry into the relevant land registers in accordance with the applicable laws. So in the engineering phase, once they had finalised the route of the pipeline, unsurprisingly, they then went about getting the land and transferring ownership to the MEP participants. That's really what was happening. That leads on to, so Bill had nothing to do with that. They are the designated operator. So once the thing was built in the Turkish sector, they were the operator. And if you could just take up as my last exercise in volume 2 of the record, at tab 29, 468. Again, I do this as a shorthand. This is an affidavit of Mr. Rowe from St Masons. It's convenient because at 468, in paragraphs 14 and 15, he identifies the fact that the Republic of Turkey has entrusted the operation of the Turkish section of the pipeline to a state authority as defined under the host government agreement. Bill is now the designated operator. The definition of state authorities, however, on which my learned friend relies, includes, if one looks at under the definition of entity, any company, corporation, whether of a governmental or private nature. So it's not about it being a sovereign body. It can be any company, private or state. The reason it's designated as a state authority is because it then brings it within the ICSID provisions, and you can have arbitration, and that's why they also have the waiver to make it clear that it is a private entity. And if one, sorry to ask you to, one more, volume 16 of the record. At tab 122, at 4617, it's actually quite difficult to read, but this is a convenient extract just below the picture, missing the first paragraph. The pipeline that became operational in June 2006 was built by BTCco, that's a private company incorporated in the Cayman Islands, and is operated by BP. It's got nothing to do with any of the states involved in this. The pipeline buried along its entire length, the Azerbaijan and Georgia sections of the pipeline are operated by BP. So the other designated operator for the pipeline is BP. So if you wanted to ask whether Bill is conducting a normal commercial operation, the answer is yes, because it's doing exactly the same as BP is doing for the rest of the pipeline. And my learned friend suggested that the assets of this company would be worthless if it's sold. Well, that's a commercial matter your lordships don't need to be troubled with, but it's wrong, because first of all, the private company can remain as designated operator, as a state authority. And if your lordships go back to volume 1, and this is, I promise, the last time we pick up a bundle, at tab 12, you have the order of the court that we have seen before, and if one goes to page 255, at paragraph 13 of the order, Bill is currently restrained from reducing the value of debts owed to it by Botaş. And those debts are set out conveniently in the Royal Court's judgment at page 242. Yes, 242. It's the judgment giving rise to the order of the 26th of February. At paragraph 55. And what it explains is, the way it operates is that Bill operates the pipeline and also the terminal, the port, and it charges berthing fees to anyone who comes into the port, including Botaş, and the debts that are restrained at the moment amount to $62 million. So the company does have, one might think, some value arising out of the commercial operation of the port and the fees that are due to it.
They're restrained by the order, yeah.
They're restrained by the order. My lords, unless there's anything further,
How much,
2 minutes
how much are they
over.
worth? Where do you see the value? 62 million?
In that paragraph. It's just,
Yeah.
Those are my submissions, unless I have any questions.
Thank you very much indeed. Yes. Yes, yes. Yes. Oh, I've failed to invite your juniors to follow, I'm afraid. That's very remiss of me. Is there, I'll give each side, perhaps, it's a bit late.
My Lord, can I start with the State Immunity Act itself? It's in Volume 1, Tab 1 of the Authorities Bundle. And I just want to go through each provision dealing with property, which you're familiar with now, but it's useful to remind ourselves. Section 6, subsection 4, refers to property in the possession or control of a state or in which a state claims an interest. Section 10, which relates to ships, talks about a ship belonging to the state, and in subsection 5 of Section 10, it broadens that to a ship or cargo in its possession or control. So no question that possession and control are very relevant for adjudication. What my learned friend's case must be is that the protection afforded by immunity from execution in 13.2b is narrower than the immunity from adjudication, because they say that property of the state does not encompass control. So in other words, my lords, there must be circumstances on that case where you cannot have adjudication about competing interests in respect of an asset that would not be protected by immunity from adjudication. I'll say that again. There may be circumstances where there cannot be an adjudication about competing interests in property, where that property wouldn't be protected by immunity from execution.
Sorry, I may be failing to follow this. Isn't it the other way around? There may be circumstances in which there is a jurisdiction to adjudicate, but no jurisdiction to execute.
My lord, I think it is the other way around, because, so I'll take it in stages.
Or the other way around to the way I've just put it?
Yes.
Okay.
Suppose an entity, a state can establish control but no proprietary interest. That would mean that there would be immunity from adjudication under 6.4, but because you couldn't rely on control on the respondent's case in relation to 13.2b, that would mean that you could execute against the same property.
But you couldn't execute a judgment of the English court because ex hypothesi there wouldn't have been one if there was no jurisdiction.
But my lord, there may have been jurisdiction in some other way. There may have been an arbitration award.
Yes, but then if there's an arbitration award, there's been a submission to the jurisdiction of the arbitrators.
Which, my lord, cannot have consequences in relation to immunity from execution.
Well,
that is
I don't quite see how you get Section 6 into this argument at all. Because
my lord,
it doesn't arise if there's immunity.
Yeah.
It does arise if Section 6 is irrelevant because there's been a submission to arbitration.
But my lord, the simple point is that it is a fundamental principle of customary international law that immunity from execution has to be broader, has to be more protective in relation to property than immunity from adjudication. And the submission...
Not in all respects, surely. Obviously, one major respect, possibly the only one in which the immunity is broader, is that it's subject to a narrower range of exceptions in relation to commercial employment and so on. You can, but I mean, does it go any further than that?
My lord, the policy is that executions are more direct interference with sovereign functions than the declaratory judgment. And if we take a step back, declining to adjudicate can have very adverse consequences on private parties who may be caught up in the dispute. That's not a concern that arises in relation to execution. I want to then take you, so that's where we stand with the Act.
If you're right that execution is not limited to property of the state in the proprietary sense, that can affect third parties quite radically.
Sorry, my lord, if property is...
I think you're submitting that property, that the immunity from execution extends to property which is not the property of the state in the legal sense of the word property.
That's correct.
So that does affect third parties, doesn't it?
Well, it affects the third party to the extent that a particular asset which is in use for a sovereign purpose at a particular time will be protected. But we would say that's not a concern which it should be as paramount as a concern to turn away private parties from adjudication before a court. And yet we're reversing the hallowed principles of customary international law by saying that actually the protection afforded by immunity from execution goes nowhere near as far as the immunity from adjudication. My lords, I just want to remind you about what Lord Diplock said about how we should approach the interpretation of the State Immunity Act. This is the Alcom case, Volume 2 of the Authorities, tab 13, page 379 of the bundle. And this is a case which is talking about subsections 2b and 4 of section 13 of the State Immunity Act. If you look at G,
Sorry, page.
page 379,
Thank you.
and his Lordship says, the Act, as its short title indicates, deals primarily with relations between sovereign states, though its provisions are capable of extension to constituent territories. Accordingly, its provisions fall to be construed against the background of those principles of public international law as are generally recognised by the family of nations. The principle of international law that is most relevant to the subject matter of the Act is the distinction that has come to be drawn between claims arising out of those activities which a state undertakes jure imperi, i.e. in the exercise of sovereign authority, and those arising out of activities which it undertakes jure gestionis, i.e. transactions of the kind which might appropriately be undertaken by private individuals instead of sovereign states. Now, my lords, there's a choice to be made in this case. Are we to focus, in looking at 13.2b, on the quality of the interest that the state has in property, or are we to focus on the quality of the sovereign use to which the property is being put? The former, in our submission, is appropriate if we're looking at absolute immunity. The latter is more appropriate when we're looking at the restrictive doctrine.
Say that again. So the former, which is quality...
The quality of the state's interest in the property versus the quality of the sovereign purpose to which the property is being put. And just as a very...
and then you said the former?
The former is more appropriate if we're applying an absolute doctrine, because that's the basis upon which immunity follows. Is it state property? The latter is more appropriate when we're looking at the restrictive doctrine, because it's a functional test, it serves a functional purpose, and that is it must protect property which is being used for a sovereign purpose. And if we go for the latter...
They're not alternatives, are they? Because the real dichotomy is between the view that it's property in the proprietary sense and the view that both tests apply cumulatively. Because I think the submission against you is that you've got to show both that there's a proprietary interest and that it is in use for a sovereign purpose.
My Lord, my submission has been all along that one has to look at the latter to come to an acceptable interpretation of the former. And the reason why we say that proprietary interest should not be the touchstone, that it would be a dangerous development to go down that route, is that if we look at simple examples of where a state may have full ownership over property, but that may have no relevance at all to a claim to immunity because that property is being used for a commercial purpose, because it's being leased on a commercial basis. Whereas a lesser interest, say a lease, and you're going to say that's a proprietary interest in a moment, but let's park that point. But suppose there's a lease over a premises which is being used for consulate purposes. Then obviously, for immunity purposes, that lesser interest in the property is far more relevant because the property is being used for a sovereign purpose. Now, why do I come back to a lease? Because you're going to say, well, that's a proprietary interest, what's the problem? It's not a proprietary interest in France. It's not a proprietary interest in Germany, the numerous clauses principle. So, in other words, it would be taking a very parochial English property law approach to a concept which has to be autonomous because we're looking at a concept which has to work in customary international law. It has to work more generally. And wouldn't it be a shame, given that the UN Convention uses exactly the same terms, property of a state, wouldn't it be a shame if that ever does come into force? The Supreme Court may have to say in 10 years' time, well, we have to draw a line under all the cases we have decided after Botash, if you're against me on this, because now we can't look at this concept anymore through the lens of English property law. We have to take an autonomous approach to this. My lords, would it make such a big difference if the assets, the shares in this case, were put in trust by the Republic so that they're held on trust by Botash for the Republic's favour? Of course, Turkish law doesn't have a concept of trust. So they've tried to do it some other way. They've done it through general legislation. But should that make all the difference? If you take a proprietary English property law approach, well, yes, there'd be an equitable interest in that case. But should that matter when we're applying a concept which has to perform a function for sovereign immunity, and of course that's a doctrine that comes to English law via customary international law? So in our submissions, control is essential because in some legal systems, that's the powers that will be exercised. They won't be exercised through nice distinctions between legal interests and equitable interests because that doctrine won't exist in other legal systems. So control is essential to ensure enough flexibility so that the underlying principle of state immunity can be applied, which is simply it needs to protect property that's being used for a sovereign purpose to ensure that essential sovereign functions are not interfered with. To take another example, my lords, there are cases where states in this country even delegate consulate functions to a private company. Now, should it make a big difference if the state owns the premises where the consulate services are being conducted, or where the state leases that premises, or where perhaps the private company owns the premises and the state enters into a contract which gives it very, very wide-ranging rights of access, of control, etc., over that premises in question? If there was a judgment debt against the private company, should the premises be taken if it's being used in that situation to perform a sovereign purpose? Of course, if you abandon the concept of control and you're looking at it through the lens of English property law, you're going to have to say, well, yeah, it should be taken. Is that consistent with the policy underlying the State Immunity Act? My lords, we're not looking at the meaning of property in this case. Of course, if property doesn't exist under a municipal law, there'll be nothing to talk about. But there's no question that shares are property. What we're looking in this case is the relationship between the state and property. We're looking to interpret of in 13.2b. And of course, there's nothing in the Act, there's nothing in that section which demands that we look at that relationship through the lens of property law. And as I've said, there are very, very strong reasons of policy why we shouldn't do that.
Well, there might be thought to be, in an execution context, reasons of policy in the opposite direction. If you've set up a separate entity and the separate entity owns assets which in normal circumstances would be susceptible of seizure to pay its debts, why can't you investigate whether it has an interest of that nature and whether the state doesn't? Why should the state be entitled to treat something as its property when it's not assets which could be used for the purposes of execution if you had a claim against the state, but it is assets which are in the separate entities' proprietary sphere, and possession or control here is not something which is normally relevant in execution, is it?
My lord, a fundamental problem with the case against us is that the State Immunity Act does not attempt to identify which assets are available for enforcement. In our view, that's a fundamental misconception. It's not a code to determine when you can enforce against assets. It's the purpose of the State Immunity Act is to identify which assets are not available to enforcement. And that distinction is fundamental. We're not deciding whether or not a state has a proprietary claim or any other type of claim over an asset in the sense that it will have consequences in property law for the purposes of 13.2b. A decision...
Why are we not doing that? I mean, surely the problem about your submission that there must be an autonomous meaning of property is that we're talking about execution, and the assets which are subject to execution will inevitably depend on the law of property, the municipal law of property in each state. It may well be that a lease is property which can be enforced against in England, but not in France or Germany. But that is a relevant difference, and it would mean that the immunity would not arise in France or Germany because it wouldn't be property of the state, whereas it would in this country where it would. That arises not from a difference in the way we approach the way we approach international law. It arises from a difference in the category of assets which are subject to execution, and the fact that this is an immunity from whatever is the law of execution in the relevant country.
My Lord, first, we're not, I don't think we are focusing on the meaning of property. We're focusing on the meaning of. And there's no reason that one appreciates from the Act. In fact, quite the contrary, because you see the reference to possession and control in other sections. There's no reason that can't be a factual relationship. It doesn't need to be a proprietary one. And the problem, if you go down the proprietary route, is that you are going to have massive differences in the way it's approached in this country and in France.
Why does that matter?
Because why should there be a fundamental distinction on the basis of whether or not you have a proprietary interest under that jurisdiction?
Because that's inherent in execution.
Yes.
I mean,
My Lord,
that's the nature of execution.
But we're not executing, my Lord. We are deciding whether or not a particular asset is protected against execution.
Yes, but that depends on whether the asset would be subject to execution if there were no immunity. The whole of this section assumes that but for the immunity, there would be a liability for an asset to be taken into execution, and says when that liability arises, these are the circumstances in which it can't be exercised. So you're bound to have differences between one country and another.
My Lord, those differences can be at least mitigated, and to a large extent the concept can be harmonised, so long as we recognise through the prism of control that there may be powers, there may be privileges under the law of other states which get you to the substantial point that you're exercising the same or similar rights that you would be as an English law owner or an English beneficiary under some other arrangement. So, in other words, we have to look at substance and not form. And as I keep repeating, I apologise I'm doing it again, a determination that something falls within the concept property of the state for immunity purposes has no normative consequences in property law at all, because it acts as a shield and not a sword. The only point you get to is that, well, that asset can't be executed today. You're not saying, well, and the state has now a property interest in that asset. It doesn't have any interest in that asset, perhaps, under property law. It just can't be enforced today. And that's the purpose that phrase is there.
No. I mean, the basis of your case is essentially, at this point, that when you can't implead a state directly or indirectly, if the proceedings, whoever they're against, relate to property which happens to be in the possession or control of a state, you say it would be curious if, when it came to execution, you could do something which would implead a state, because if the state has possession or control, you say it's being impleaded if the property you're executing against is in its possession or control. That's the basic incongruity you're trying to build on, isn't it?
But, my Lord, one also has to remember in relation to Section 6.4 and the cases, the older cases from the Christina onwards, and Lord Sumption, in a sense, has made this point, but now it's subject to the additional hurdle of having to demonstrate that it relates to a sovereign transaction. So if the Christina was decided today, it would have to be the case that the court would have to come to the conclusion that the decree was a sovereign act, and right, therefore the additional...
Having built in the way I say, you then support it by saying it's not as bad as all that, because there's the qualification that if it's for commercial purposes, you'll be able to execute anyway.
The point is, my Lord, that there's just no mischief that is caused by having flexibility in the tests that's applied, both in relation to adjudication and in relation to execution, because different legal systems may operate in a different way in giving the state something that would look a lot like an English trust or an English beneficial interest. But we're looking at substance and not form, and this can't take the course of technical property distinctions in English law, and all their lordships in the Christina, in Adolphus Mieg, in Racontula, they made this point. We can't look at this through the prism of English property law, and they said that for a very good reason. My Lords, in relation to the point that there's some sort of strong presumption that is created by the separate entity. My lords, what is the difference for immunity purposes between an organ of the state that enters into a commercial transaction and a separate entity that enters into a commercial transaction? Answer is no, none. What's the difference between an organ of the state that enters into a sovereign transaction and a separate entity that enters into a sovereign transaction for immunity purposes? Answer is none. And I'm talking about adjudication. So why introduce all these presumptions through Section 14 and otherwise, which don't exist in the Act, to resolve these very basic questions? Why apply a Trendex test, which looks at the relationship between the state and the separate entity in the abstract, which is irrelevant for state immunity purposes? As I said in opening, a separate entity could be vested with sovereign power for one day, have absolutely no other relationship with the state, and has never done so historically. Irrelevant. If it's exercising sovereign authority today, and the acts that arise as a result of that exercise of sovereign authority are the subject matter of a dispute, then there may be immunity. But it assists us not one bit to go through the types of Trendex factors to determine the general relationship between the state and the separate entity. So long as it's common ground that it is, that a state can have a proprietary interest in property that's owned by a separate entity, then it's just crystal clear. We have to start and finish with 13.2b. Calling on presumptions that are alleged to be in the indices of Section 14 just simply don't help. My lords, Section 14.2 does not apply to enforcement. Lord Gough did not say otherwise in Kuwait Airways, and we have to be very careful in interpreting that provision and not to give violence to its plain meaning. It uses exactly the same terms as Section 1. Section 1 is clearly only dealing with immunity from adjudication. And the sovereign acts, and it relates to a point that Lord Sumption made, the sovereign acts have to be those done in the proceedings. So we're talking about the subject matter of the proceedings. We can't go back in time to somehow look at sovereign acts in the acquisition of property, because that would expand the immunity beyond any bounds. Imagine you could go back to the original nationalization decree in Soviet Russia and say, well, all this property was vested originally by virtue of a sovereign act, and therefore whatever purpose it's being used for today, it should be immune. That can't be right. So Section 4.2 is concerned with adjudication and nothing else, and that's the only way that 14.3 has any meaning either. Very quickly on the special legal regime, just a couple of points. A point was made by my learned friend that the Turkish law regime would apply to all assets owned by a separate entity. That's not the case. The Royal Court found very specifically that it only relates to subsidiaries, shares in subsidiaries. So it's not a case of extending to all assets owned by a separate entity. In relation to the involuntary transfer point, well, the simple reply to that is that no question would have immunity if we own the shares. And of course, being the owner of the shares doesn't protect you against an involuntary disposition. So the fact that the Turkish law powers don't protect you either is neither here nor there. Finally, on sovereign purpose, there was an attempt to say by my learned friend that that bill is not a state authority for the purposes of the documents.
No, I think he said that the bill was a state authority, but the reason for making it one was ICSID. So it got within the ICSID arbitration.
My lord, he took us to an affidavit on English law, which purported to say that a state authority can be a private entity.
Yes.
That's completely wrong, my lord. Can I take you to page 3310 of the bundle, volume 12, tab 112. And the reason why it's wrong is that the extract which is set out in Mr. Rowe's affidavit omits the definition, a very important definition, of a state entity. So in other words, he only refers to a definition of entity and not state entity. But if you actually go to the definitions, immediately after state authorities...
Was it 3312?
3310.
10.
If you go immediately after the definition of state authorities, you have the definition for state entity. And just looking at the definition of state authorities, and we've seen that Bill is a state authority that's expressly recognised in the third contract. It can either be the government, any and all state entities, and any and all local authorities. It's obviously, Bill is not the government, it's not a local authority, it has to be a state entity. And then you see the definition for a state entity there, and of course it meets that definition. So we completely reject the idea that Bill can somehow be a private entity for the purposes of these contracts. My Lord, subject to an administrative point, I discovered this morning before we started that not only is this your final day of hearing, but it's also your birthday. And under the circumstances, it's quite extraordinary on this day of all days that you were prepared to extend the hearing after lunch. But my Lord, of course, I endorse entirely what my learned friend said and express our admiration and plain awe, really, for the length and the very long and distinguished judicial career, and also the immense contribution that you've made to the common law. I can't help but repeat a little anecdote, and that is that when you were a Court of Appeal judge, you were very, very generous in quoting and approving of an article, my first major publication. It was the Occidental against Ecuador case. And what you unwittingly did was actually launch my academic career, because at Cambridge University they actually referred to that during the interview, and quite frankly I had no other claim to fame at that point in time, other than I was approved by Lord Mance. And one could easily argue that it's all been downhill for me since then. But my Lord, I ended up leaving Cambridge a few years later. I didn't enjoy it very much, but I'm hardly going to hold you responsible for that. But so, my Lord, we wish you very well for your retirement, which predictably may last about 2 weeks before the deluge of arbitration appointments starts to kick in which case some of us will be seeing you even more frequently. And you may well reflect, I suspect, in a few months that your workload hasn't changed at all. In fact, the only thing that's changed, really, at the end of the day, is the carpet. But my Lord, sir, I did mention one administrative matter, and that is the question of the UN Travaux Préparatoires.
Yes, quite.
And what the proposal, and I'm afraid I haven't had a chance to discuss this yet with my learned friend, but the proposal we have, because we looked at it overnight, and I'm afraid the short answer is that it has to be a long answer. There are a number of documents that make up the sort of sequence to demonstrate how this has evolved.
Yeah.
We will obviously say it's perfectly consistent with how the academics described it. But what we thought we would do is try to agree with the other side on the documents that need to be put before you, and then simultaneously, once we've agreed to that, submit a short commentary on what we think the significance of those documents is. And we were proposing to do that within 2 weeks.
Oh, very acceptable. Thank you very much indeed. And thank you for your very handsome remarks. I'm reminded that in the Court of Appeal about another South American republic, I don't think it was Ecuador, it may have been Colombia, but I forget it. As counsel, I felt a certain resistance when the court addressed my opposing counsel as Professor Higgins. But I think in the light of what you told us about your academic career, I can thank you, Professor Douglas. It's been a great pleasure to sit in this court, and I shall miss it, but others will take it on with just as great enthusiasm, I think. And I'm grateful to counsel in this case. We all are, for their submissions, careful and eloquent and well thought through, and they will repay study on paper, which we will be grateful to be able to do when you send us the remainder of the transcript. That said, the board will take time to consider what advice it will humbly tender to Her Majesty. We'll adjourn.